Jackson, who represented the US at the Nuremberg trials, if you remember, as the special US prosecutor, sitting Supreme Court judge sent as a prosecutor. He, being the best lawyer of the three, put it on the ground that if you cannot criminalize a son for his father's activities, how can you criminalize any Japanese of ancestry which may go back 5 generations for what his father may or may not have done? That is, come here. So he would strike it down on that ground. He also said correctly that in 1944, where is the question of an imminent threat of invasion? There is none. So we find again that somehow or the other, the US Supreme Court in the time of supreme need, that is at the time that a war was going on, failed somehow or the other to protect the right of citizens who were from Japanese ancestry. Congress ultimately in 1988 undid the damage to some extent by passing a law saying that for everybody who was wrongfully so confined, they should get damages of $20,000. We now move to the UK. Was the UK any better before coming to our country? A First World War judgment in Rex versus Halliday, 1917. House of Lords was faced with something similar. This time the First World War was going on. A man called Arthur Zadig, German, who was naturalized in England in 1905, that is long before the war started, was preventively detained under a Regulation 14B, which was passed on the ground that you could detain anybody who had a hostile origin or association. Now the court, Lord Finlay speaking for the majority, said again, we are in times of war, we are in times of trouble. It is not for us to judge, it is for the executive to judge. And therefore, this kind of an order would pass muster. The dissenter, please notice there's always a dissenter, fortunately, in all these cases. Lord Shaw went way back to Magna Carta, said that in Magna Carta itself, something like this would not have passed muster. Quoted the famous 39th and 40th article. Said, where is the law of the land? Where are the judgment by the peers of the law of the land? Where is the fact that justice cannot be denied, delayed, sold? It is being denied to a man who has been naturalized and now who seeks cover of our law because he's a UK citizen. Nothing has been shown to us. And the executive said, we will show you nothing to show that he was involved in any anti-national activity. So he exhorted, he went back to Magna Carta, went back to the Petition of Rights, 1628, went back to their Bill of Rights of 1689, quoted profusely from all of them, and gave a very strong dissent, and ultimately ended by saying, we are judges, we have to administer law, we are not politicians administering policies. So it was another hard-hitting and good dissent, but unfortunately only a dissent. The same thing happened in the Second World War. Again, the House of Lords was faced with a judgment, the famous judgment of Liversidge versus Anderson. And here again, unfortunately, the majority refused to look after Liversidge, who said he had been wrongfully detained. Not only was he wrongfully detained, he was also claiming damages for that wrongful detention and only said, give me the grounds, tell me why you have detained me. House of Lords said, no, sorry. The satisfaction of the Secretary of State is final, and it is not that we can say that his satisfaction is something subject to judicial review. If he thinks X or Y, good enough. Again, in a very hard-hitting dissent, Lord Atkins stood up. And Lord Atkins' judgment has come down to us as one of the classics of legal literature. It used some very famous phrases. Amidst the clash of arms, the laws are not silent. One of them. Beautiful phrase. Another, that I do not like judges who are more executive-minded than the executive. A third, unfortunately, the Court of Appeal and my brethren seem to be affected by the subjective virus. So again, hard hitting. And finally, he quoted from Alice in Wonderland and said, ridiculed the fact that if somebody has reason to believe or somebody is to be satisfied, the Secretary of State, then he cannot think that he has reason to believe or think that he is satisfied. He said, if I have broken my leg, it doesn't mean that I think I have broken my leg. Either I have broken my leg or I haven't broken my leg. And quoted this from Alice in Wonderland. When I use a word, said Humpty Dumpty to Alice, I mean the word to be exactly what I say it is. So Alice talks back to Humpty and says, can you make words mean different things? Humpty's answer was, it depends on which is to be master, that's all. Now with this hard-hitting, brilliant speech, at least something of the law was salvaged by a dissenting judgment. When we come to our country, we find that our institution, the Supreme Court, is firstly an institution set up under a constitution which has learned from all these mistakes. So there's a very fundamental difference between the articles in our constitution and the US constitution or the unwritten English constitution, so to speak. Here not only do we have Article 32, which itself is a fundamental right to enforce fundamental rights directly before the Supreme Court. But we also have a very important article, 145(3), which to the best of my knowledge is not there in any of the older constitutions, which is that this weakest or least dangerous branch, so to speak, is the ultimate arbiter of the Constitution. A minimum of 5 judges will tell us what this Constitution means, and nobody else. Very important. Apart from this, the High Courts are given vast powers under Article 226. And the Supreme Court itself has a very vast appellate jurisdiction under Article 136, perhaps the vastest in the world, because it can pick up something directly, in theory at least, if not in practice, from any judgment, order, determination passed by any court or tribunal all over the country. And one other very interesting article, 142, which again I don't think exists in any other constitution, which is that as the buck now stops here before the final court, the final court is given the power to do complete justice in every cause or matter before it. You remember Justice Jackson's famous words. We are final not because we are infallible. We are infallible only because we are final. And if there were a super Supreme Court sitting above us, he said, I have no doubt that a large number of our decisions would be set aside. But the buck must stop somewhere. And when it stops somewhere, that ultimate court must be also given the power to do complete justice in the cause between the parties. Apart from that, we have one other very important article, 144, which deals directly with what Hamilton said, that every authority in this country is bound to enforce the Supreme Court's judgments or orders. Now, with these vast powers, has this court also lived up to what it is expected, at least by the founding fathers? I would say yes, in large measure. Because as an institution which is meant to look after the rights of the people, in ordinary times it has done very well. Golaknath's case, for example, 11 judges ultimately said, you Parliament cannot touch fundamental rights at all by constitutional amendment. Even though that was undone by Keshavananda Bharati's case. Keshavananda Bharati laid down something which has never been laid down anywhere else in the world, at least up till 1973. Namely, that a constitutional amendment can be struck down on substantive and not procedural grounds. And you know, of course, what the aftermath was, because you had a very strong executive at that time. So the aftermath was the second supersession. The first supersession, incidentally, took place before this, because a man called Justice Imam, unfortunately, lost his mind while on the bench. And Gajendra Gadkar was therefore made Chief Justice instead of him, which was understandable. But this time, the moment the judgment was delivered on 24th April, and Chief Justice Sikri had 1 day to go, an order came superseding 3 of the senior judges who happened to side with the majority, including Suresh Bhai Shelat's uncle, Justice J.M. Shelat, who would have then, in the ordinary succession, become next Chief Justice. Now, here also I must tell you something interesting. Originally, in the federal court, there was nothing like the senior-most puisne judge becoming Chief Justice. In fact, after Sir Maurice Guire, Justice Vardacharya, who was the next senior-most judge, was passed over, and an Englishman called Patrick Spence was brought from outside as Chief Justice. So if at all, when our Supreme Court was formed, we already had a precedent of somebody else being brought over the heads of the judges to become Chief Justice. Justice Kanya, as you know, became our first Chief Justice and would ordinarily have carried on for about 11 years. He was 54 when he was appointed. Unfortunately, he died within a year, which opened up the succession. And the moment it opened up the succession, the major problem the government of the day faced was to try and see that Justice Mahajan did not become Chief Justice. Because the then Prime Minister and this great judge had had many differences in the past, particularly when he happened to be the Prime Minister of Kashmir in 1947. So there was first a move in which the Prime Minister tried to bring Justice Chagla from Bombay over the heads of all these gentlemen. Apparently, it seems that all of them said they would resign, so that unwittingly, therefore, the executive backed off, and the seniority principle, therefore, got established. When Justice Patanjali Shastri retired and Justice Mahajan's turn came, again the same thing was tried. This time, to try and bring forward Justice B.K. Mukherjee, who was the next puisne judge. Again it failed. So that at least till the supersession, this particular principle seems now to have become part of our constitutional law. With the supersession, of course, Chief Justice was the 4th puisne judge who became Chief Justice, namely Justice A.N. Ray. Now, even though an emergency was declared here, which was like war, because like you had World War I, World War II, which were, of course, of a much greater magnitude, here you had an emergency declared taking away all fundamental rights. The first thing that the court was faced with was an amendment passed, the 39th Amendment, which actually put the Prime Minister and 2 other dignitaries, President and Vice President, above the law. 5 judges, including Chief Justice Ray, were unanimous in saying that it could not pass muster for various reasons. Used the Keshavananda Bharati principle and struck down the amendment. So the very first thing that they did after the emergency was declared was a very laudable thing, namely to strike down an amendment which would otherwise have subverted the entire constitution. But the second thing they did was what still sticks in my throat at least. 9 high courts had held in this country that habeas corpus writ petitions could be issued even in an emergency, even with Article 21 gone, in limited circumstances. What if, under a preventive detention act like MISA, they wish to catch Mr. X and they catch Mr. Y? Can Mr. Y not come to a court and petition it saying, the warrant and the detention order both say, it is Mr. X, I am not Mr. X? Can he also not say that the detention order is procedurally bad? There are certain safeguards provided in the Act. Can he not petition a court to say that those safeguards have not been followed, therefore please release me? 9 high courts held that yes, even though Article 21 may have gone, Article 226, which gives the power to high courts to issue writs, has not gone. And the habeas corpus writ is available in these limited circumstances. Unfortunately for us, again, like the US Supreme Court, like the House of Lords, in times of trouble, in ADM Jabalpur's case, a majority of the judges left the country now. And upset these 9 high courts, stated Article 21 was the sole repository of personal liberty, and said that even in these limited situations, habeas corpus writs will not issue. It is Justice Khanna alone who stood up, which again brings us back to Chief Justice Warren. It is not necessary that a great judge be a brilliant judge. By no means could anybody say that Justice Khanna was as brilliant as the colleagues who formed the majority. But he was the man with character. He was the man who stood out. And he stood out on every score. First and foremost, he said, Article 21 cannot be said to be the sole repository of liberty, and gave very good reason. 2 of which at least were that we have a UN charter now, which tells us these are fundamental, these are inalienable, these are natural rights, which inhere in you because you are human. And the other was by a process of legal reasoning. Article 372 says that the common law, which was the law in British India at least, before the Constitution came into force, will continue. Under the common law, you certainly could, in the time of an emergency, petition a court, maybe on limited grounds, for a habeas corpus writ. So he said that common law has not been effaced. But ultimately, this great judge became the next super session. And he's supposed to have told his wife the day he delivered the judgment that he had lost his chief justiceship, which in fact happened. Mr. Nani Palkhiwala wrote a great article on him. And I remember his last words, which were beautiful. To the stature of such a man, that is Justice Khanna, the Chief Justiceship of India can add nothing. So we have seen